Law Simplified with Justice is anchored by Justice Maduforo. Tice Madox Solicitors is results-oriented, but with a distinctive approach tailored to our clients' needs in our specialist fields: immigration law, criminal law, employment law, commercial law, family law, and contracts law. We are well equipped in our litigation and advocacy for the benefit of our clients, corporates, and individuals. Why not visit us at 5 Oakfield House, Oakfield Road, Ilford, London, IG1 1EF. We are just 15 minutes from Liverpool Street Station. Tice Madox Solicitors. Try us. We are professional.
Hello, ladies and gentlemen, and welcome to Law Simplified with Justice. I remain Justice Maduforo. I am a solicitor of the Senior Court of England and Wales. I'm also a barrister of the Supreme Court of Nigeria and Police Station and Magistrate Court Duty Solicitor, accredited and licensed by the Ministry of Justice under the authorization of the Legal Aid Agency of the United Kingdom, emanating and authorizing me to represent people of the police station free of charge at the initial stage, and then if the matter goes further to the Magistrate Court, to the Crown Court, subject to means testing. And this is talking crime. Ladies and gentlemen, I am a specialist in immigration matters. I'm a specialist in employment matters. I'm a specialist in contract matters, and of all sorts, commercial and otherwise, from multinationals to national contracts, from any areas of law, any areas of practice that your contract lies in, from oil and gas to construction to business, business law, business affairs. And these are the issues that you have Tice Madox Solicitors to assist you without any hassle. This program educates you. This program awakens your consciousness. This is not a legal advice program. Therefore, you must not act on whatever you hear me speak on this program, nor all my discussants on this program. Today, I'm talking on immigration law, errors of fact, and errors of law. Immigration law, errors of fact, and errors of law. The question now will be, where is the errors of fact coming in? And where are the errors of law coming in? Now, I'll give you a simple explanation to that. When you make an application to the Home Office and you have put the facts depending on the category of application you've made, there are so many types of application and categories of application you can make to the Home Office. And when you've made that application to the Home Office considers the facts, which is the facts that support that application you've made. In the process of considering the application by the caseworker acting on behalf of the Secretary of State, will either decide and agree with you or disagree with you. When they disagree with the facts you presented, and which you do not agree with, and you dispute the fact that they did not consider the facts which you put before in your application, then that constitutes errors of facts. And when errors of facts are built, or rather when the Home Office or the decision maker or adjudicator begins to rely or relied on errors of facts. Therefore, when it comes to the final decision, which was built on errors of facts, automatically means that there will be errors of law, which means that he is relying on wrong error, or wrong precedent, on wrong facts, and then have not made a decision based on that wrong facts. And then that decision may clearly come out from errors of law. However, I will still take you up to discuss also examples where errors of law occurs. But errors of fact are those of them that are made by the first decision maker in the first instance. Or sometimes the court can still make errors of fact based on the fact that they consistently are completely ignored the real facts presented before them. And in that circumstance, the errors of facts have occurred. But you cannot solely rely on errors of facts made by the court. You must mix it together and cap it up with error of law as a result of reliance on an error of fact. I will kind of make sure that I break this down in the way that you understand. Most of you make this application to the Home Office, be it application for student visa, application for visitors, settlement, limited leave to remain, discretionary leave to remain, humanitarian application, Article 8 applications, all sorts of applications that you may, even naturalization application, or citizenship application, indefinite leave to remain application, also applications, point-based systems application, all sort of point-based systems. That's all different types of applications. The question is that you rely on facts when you make that application. And now the Home Office or the caseworker acting on behalf of the Home Office have relied on the wrong facts or have distorted your facts. Facts can easily be distorted by the Home Office, especially the caseworkers. My firm is inundated with applications that we refuse when people come to the firm. When they come to see me and I look at the decision letters and the question I ask them, straight away they will tell me that the Home Office got the facts wrong. Sometimes the Home Office get it wrong, the fact that they will attribute you to come from a different nationality, which is not where you come from. They will attribute your position at times. They may attribute that you're married when your application states you're single. Sometimes they'll make these errors of fact that you are applying with other people when it is not this position when you made the application. There are so many inexhaustive lists of wrong facts relied on by the Home Office when they make application, when they make decisions. And when the decision is made, the only way you can change that is by appeal, if you have one. If you have a right to appeal, then you can make that correction as time goes on. But if you don't have a right to appeal, what happens? That these are all the areas you need Tice Madox Solicitors. That's when you need me to harness your circumstance and begin to propound the case further. Now, most of you have this premonition on this idea that once application is refused, you have no right to appeal, you head to judicial review. Sometimes you don't want to just make applications that are worthless. That is why when you come to a firm like Tice Madox Solicitors, expert in dealing with judicial review applications and appeals and representations and reconsiderations, we'll be able to tailor in the facts of the right option that befitting your own facts. And that's why you come to me. It is not just judicial review. When I clerk and take instruction from my clients, it is very obvious that if they've gone somewhere, they've given them a different set of actions. And these actions are completely different from what should be in the position. Tice Madox Solicitors tends to figure out, factor in your facts with the right option to take. And once we plug it in, we're not going to mess around with issues of trial and error. We don't do trial and error in Tice Madox Solicitors. We straight on deal with the facts. And when you get the facts correct, then you are in for success. So why don't you want to take an opportunity for that? If you are sitting on an application by the Home Office, which they have considered your application, and in some instances have found that there's an error of facts, or you found there's an error of facts in that circumstance, but you have no right of appeal, run to Tice Madox Solicitors. Now, these are errors of fact, which the adjudicator first application can decide, not just the Home Office. Some of you applying to council can also get the facts wrong. Some of you are on welfare benefits, the facts are wrong. Some of you are even facing a criminal investigation by the police, by the Department for Works and Pension, by Her Majesty's Revenue and Custom, by the Customs, by the Serious Office, Serious Crime Office, SCO, by the other sectors, statutory bodies of different organs. Some of you also facing the National Illegal Lending Money Team. Some of you are facing so many sort of fraud and all the rest of them. Some of you are also facing matters in the county court. That stage, either made by the council or whoever this body that I've discussed with you about, or some of you are even in employment tribunal, facing your ex-employers on the basis that they got their facts wrong, on the basis that they relied on the wrong facts and made a decision that is detrimental to you. Now you run to Tice Madox Solicitors, expertise in dealing with these matters, detailing the facts. Those are the errors, those are correct. Even the facts that are correct but are wrongly applied could also emanate to errors of facts. Now, these are, especially for this purpose of this program, is the errors of fact relied on are made by the Home Office. Then that can be corrected by Tice Madox Solicitors. When you move to that, now decision has been made. Where did error of law come in? Now, Home Office can also make the error of law in the sense that they have applied the rules wrongly while relying on wrong facts. I say this quite often, but because Home Office is so inundated with so much applications, so much inquiries, so much correspondence before them, they are working with precedents and they work with precedents. These precedents, the caseworkers are not diligent enough to avoid and correct and read in between the lines and remove those that does not apply to that particular case they're dealing with. In that circumstance, they will rope you in with the precedent they already have on their system. And that is what you're going to run with. Let me even tell you this. Some of you have received an application from the Home Office and they've said that you have criminal convictions and you have not even been arrested or spoken to by a police officer since you've been in the United Kingdom. If you're sitting on such errors of facts, run to Tice Madox Solicitors, telephone number on the screen, and book an appointment to see me in the office, ladies and gentlemen, and get it sorted once and for all. Some of you have, due to some errors of fact imputed in your application, you've been consistently been stopped and interrogated when you leave the United Kingdom, come into the United Kingdom through all its exit points, from the airport through the sea. Some of you have found this difficult, and each time this information and wrong facts imputed in your circumstances, in your personal record, it flashes up whenever you come in or you live in the United Kingdom. And that delays you consistently and obviously embarrasses you. If you're sitting on such facts, and each time the Home Office is stopping you, interrogating you, you don't understand why, run to Tice Madox Solicitors, we unravel all that. Those errors of facts have been imputed in your personal record, we will rectify them, ladies and gentlemen. Ladies and gentlemen, taking you to the errors of law. Errors of law are now those made by the Court of First Record. The Court of First Instance, which means that the First State Tribunal has now heard your facts. If you were given right of appeal, heard your facts. On hearing your facts alone, the Immigration Tribunal have now relied on the wrong facts, even if it's the right facts, and have relied on the wrong application of the law. Remember, the first one is Home Office. They can rely on the wrong application of the rules, which is the rules of evidence, or the rules of immigration rules. When they rely on that, they make that application wrongly. Errors of a court. The First Court Tribunal makes that error as well. And when they make that error, whereby the judge of the First Year Tribunal, Immigration Tribunal, decides on your application, and on deciding that application, and if found that either the Home Office were correct in their decision to refuse your application, now, without consistently and meticulously looking at the rules and the law, guiding them, also exercising the discretion when it needs to be, especially when matters are of peculiar nature, when matters are of peculiar and the circumstances are peculiar, of which the judge is expected to exercise his discretion, given and granted by the court or by statute. The question now will be, would that constitute errors of law? Some may not. But when you come to Tice Madox Solicitors, when to take this instruction from you, we sip it together with the facts of the case and with the judge's comments and decision, which will contain in the notice of decision from the tribunal. And we'll be able to look at the laws, the statutes, the case laws in the past, or the courts of records, and I will be able to determine whether the judge ought to have exercised discretion or not, or ought to have looked at the rules more clearly and more considerably. When they fail to do so, they end up with wrong judgments. Now, some of you think the judge has refused application and therefore that ends your case. Do not think so. Run to Tice Madox Solicitors until I say so, that the judge has made a correct assertion of your case, has made a correct assessment of your case, the judge has come to a correct decision, then you will know that your case is not going anywhere. But when I tell you that, then you can run with my advice, because I'll be meticulous and thorough in taking instruction from you, from the past, the history, what you said. At some certain point, I will also have to look at the transcript of the appeal. Now, this is talking about errors of law made by the Court of First Record, Court of First Instance, the Immigration Tribunal, or the Employment Tribunal. Now, when they make these errors, or also there are other tribunals. There are other tribunals that do these decisions on the first record. Also, there will be tribunals from the disciplinary tribunals of all different professions, like the Solicitors Disciplinary Tribunal, the Medical and Dental Tribunal. There are so many tribunals on the first record. Now, when they get their facts wrong, they rely on wrong error of law. Or even when they got the facts correct, but they applied the law wrongly, then that will be error of law. These things come up. Now, if you, for the purpose of this discussion, is immigration, and that decision has been refused by the first tribunal, and you think obviously they will give you the opportunity within 14 days to make your application to for permission to the upper tribunal to appeal based on error of law. That is only where you can now appeal the decision of the first record. Now, in some certain circumstances, there will state it clearly it's only for the error of law. But you need to ensure that you understand the facts correctly and that the judge actually took the facts into account correctly. And then you can appeal based on the fact that errors of law has occurred. Or the judge has misapplied, misguided himself, miscommunicated himself, or misdirected himself. Or the decision was perverse in such a way that it cannot stand. Now, how do you determine these things I've said? It's only when you come to Tice Madox Solicitors. I'll be able to determine where the judge got it wrong. I'll be able to determine where the error of law have occurred. I'll be able to determine where it needs to be done accurately and properly. That's what you do when you come to Tice Madox Solicitors, ladies and gentlemen. That is the errors of law, and that is errors of facts. Now, there are circumstances, as I said, when the errors of law or facts have occurred, and when the errors of facts also has occurred. When these circumstances pertain itself and present itself in your case, then you have an option to carry on. And I will encourage you, when I see there are green lights, there are more than 50%, 60%, 80% chances of success, I will let you know. Decision will be yours to decide to take it further. But I tell you something, if you want to get results, you do not want to take the yes answer or the no answer of the first year tribunal in the immigration sector and you bury it there. No, you take it further. There are courts of record that have come up with different decisions. The courts of higher courts have slammed the lower courts for the errors. Some errors are blatant, in such a way that is very open, conspicuous, clear, crystal, such a way that the first year judge ought not to even have taken that route. But he does, or he did. When he did that, then what happens? Do you want to accept it? That's why you come to Tice Madox Solicitors. We take time to unravel this, to take time to look at these cases and see how we present a good advice to you and how you can sustain a win-win situation. At Tice Madox Solicitors, we are very passionate that you succeed. And I am very passionate that you succeed in your application. I'm very passionate that you succeed in your appeal. I'm very passionate that you succeed in your judicial review. I'm very passionate that you succeed in that application you make the first time. I'm very passionate that you succeed in your reconsideration. I'm very passionate that you succeed in your representation. I'm very passionate, ladies and gentlemen, that you succeed in your asylum claim. Remember that we deal with immigration and asylum. Both of them are the same, with different rules that apply because of different sector between the circumstances of the first and the circumstances of the other. Me being asylum and immigration, but they are the same. Fear of persecution in asylum. If you have that, you nursing that, you feeling that, you thinking that, run to Tice Madox Solicitors. Ladies and gentlemen, I have been discussing immigration, errors of fact and errors of law. And I have also explained to you where errors of fact may likely occur and at which stage. And also at the errors of law where it could occur at which stage. And whether or not the fusion between errors of fact and errors of law occur at the same time in the first court of record, which is the first court of first instance. I will take a short break. When I return, I will take it further to discuss with you the case laws, whereby these errors, the court have given guidelines on what to do when such situations occur, and what the courts of record, the higher courts, does when such come before them. Do not change the dial. I remain Justice Maduforo, your preferred solicitor and your preferred firm, Tice Madox Solicitors.
Tice Madox Solicitors is results-oriented, but with a distinctive approach tailored to our clients' needs in our specialist fields: immigration law, criminal law, employment law, commercial law, family law, and contracts law. Tice Madox Solicitors. Try us. We are professional.
Hello, and welcome back to Law Simplified with Justice. I remain Justice Maduforo. Now, I discussed with you the errors of fact and errors of law and what the case law says about it. Now, before me, obviously, I deal with these matters of firsthand in the courts of records. And when I attend court and I deal with these matters, I present my matters emphatically, vigorously, thoroughly, robustly, strongly, because I know my submissions. And when the courts and the judges appear before understand me, they will follow my guidance. The judges want you to guide them. The judges don't know it all. They want you to present a sound argument before them. They want you to persuade them, ladies and gentlemen. That is why when you go to court to present yourself, how do you want to persuade the judge when you don't even know the case law you want to put forward? What you are merely saying before the judge is a motion. Plea. The court do not deal with plea. The court do not deal with begging. Some of you go to court and you're begging the judge. That is not the position. Some of you go to court and crave emotion by crying before the judge when you're representing yourself as a litigating person. How will that work when you have not presented fact before him? When you've not been able to show that home office have made errors in your ground of appeal, which is why the court is there. The court is not there to wipe your tears when you're crying to them. No, the court is not there to be swayed because you're crying or because you are emotional. No, the court is there. They will show the empathy at that time. Obviously, make sure that you're okay. But at the end of the day, the position will be, how have you been able to show before the judge that what your ground of appeal is sustainable, is believable, is convincing, can be relied upon, can be used to overturn the decision. That's why you come to Tice Madox Solicitors. Not only do we show our empathy towards our clients, we also override it by presenting solid ground, because at the end of the day, when you succeed, you will smile forever. There's no point to give you a temporary smile. We'll give you permanent smile. Permanent laughter, which means that when we succeed in your appeal, you laugh all the way through. You smile all the way through. Even when you cry, it will be tears of joy rather than tears of sorrow. Ladies and gentlemen, Tice Madox Solicitors understand you. We understand you, and I understand you. I understand where you need it to be corrected. Now, moving away from there, briefly, the court have stated in certain areas in record before me, in the case of Iran against the Secretary of State, this is a 2005 Court of Appeal decision, which made clear where the errors of facts of a court, how to correct them, and also where the errors of law, what pertains to errors of law. Ladies and gentlemen, the court have made it clear that when the errors of fact occur, it will not only be corrected by mere oral evidence, it needs to be supported with documentary evidence. It is essential you understand that. These are, amongst others, amongst other decisions, amongst other guidance given by the Court of Appeal in the case of Iran against the Secretary of State. Now, the court gave that guidance. The fact that there's an error of fact, you need to clarify that error of fact, not just on oral evidence, it needs to be documentary. Where do you get the documentary evidence? I will explain that. Remember that not all things discussed on this program are the things that you need. They are just opinion and bullet points. The main informations and the main substance will be filled in when you come to Tice Madox Solicitors. I deal with the most difficult cases. I deal with those complex cases you think nobody else can get. Even if you're facing one now and you're not sure of how it's panning out, and they're complex in nature, they're complex in circumstance, and it's a very touching circumstance and a very important circumstance that you're going through, that you expect that it must be a successful one. They run to Tice Madox Solicitors. I will discuss all that. The most difficult ones you think you can succeed, I will find a way. Ladies and gentlemen, the laws are made a double-edged sword. The laws of each land, of any country, is a double-edged sword, which means that you can use one on the other edge and use the other on the other edge. So if the law is hitting you down on the face of it, at the back of it again, you can also use it to pierce it through, ladies and gentlemen. That is why the law is double-edged. And for those who understand how the intricacies of the law and how to apply it and how to read it between the lines, apply technicalities through your circumstances to achieve a win-win situation, ladies and gentlemen. That is what I'm talking about. Now, this court have ruled on that you will not upturn wrong errors of facts, by just relying on oral evidence. There must be some few documentary evidence. How do you get that? Assuming you don't have one, run to Tice Madox Solicitors. I will not tell you that. Until you come to Tice Madox Solicitors, we will discuss with you how next we can deal with that from the next step further. Ladies and gentlemen, that is discussing that. And we'll go further to discuss the issue of the errors of law. The errors of law, the court has made it clear that errors of law will be making a perverse or irrational finding. So what means perverse finding is another thing altogether. But irrational finding is something else that is quite abound when judges make decisions. When they fail to follow the clear principle of law that is already presented before them. When that occurs, then that means clearly that the court has negated, has deviated, has completely shifted from the duty of looking at the guidance, looking at the law, applying the law correctly. When it's been applied wrongly, then you are bound to challenge it. This is the Court of Appeal decision. There are so many guidance failing to give reasons of why they arrived, or the reasons are very faint, reasons are not cogent, reasons are vague, reasons are not direct. These are failing to give account of the resolution of the conflict, what they have arrived at. The court has dealt with that and have not given this guidance, which the lower tribunals or lower courts must abide. I do not want to emphasize on my expertise, emphasize on things I do, but it's for you to take decision and know from the point I put before you today, you will understand that. You understand that is in your best interest to pick up the phone and call Tice Madox Solicitors to speak to me or any of my members of my team. Come down to the office. We will take detailed instruction from you, but you must pay consultation fee in order to receive our expert knowledge, which will pass over to you in analyzing and advising in your case. Ladies and gentlemen, I wish I have so much time to discuss, and I don't even have any time at all. I just started and time is up. But this is to kickstart your consciousness to come to Tice Madox Solicitors, to come and see me one-on-one. And we'll be able to deal with your matter as it comes your way. Till next time I come your way again, I ask you to go to YouTube and watch some of the program. Give us a call on the telephone on the screen. Also check us on our website, www.ticemadox.com. Add us on Twitter as well, @Tice_Madox. And then also follow us on Facebook as well, on Twitter, and as we follow on as well. Ladies and gentlemen, till next time I come your way, I remain Justice Maduforo. I'm a solicitor. And this is Tice Madox Solicitors. Your time has come.
Tice Madox Solicitors is results-oriented, but with a distinctive approach tailored to our clients' needs in our specialist fields: immigration law, criminal law, employment law, commercial law, family law, and contracts law. Tice Madox Solicitors. Try us. We are professional.